All right. Good morning. Welcome to JELCAR. The record will be done from the video, so everyone please be careful to identify yourself and use the microphones. For seating, Representative Grota can sit in for Representative Hatch, who won't be here, and Senator Gray for Senator Whitley. And Senator Fellows and Hacken Phillips are on deck. Okay. The minutes of the previous meeting.
Move to approve as written and presented.
Second.
Any comments, corrections, or questions about those minutes? Seeing none, those in favor?
Aye.
Those opposed? Okay. The consent agenda. Is there does anyone wish to remove something from the consent agenda? Yes, Representative Lamb.
Thank you, Madam Chair. If I had a question about whether the ELL definition would impact school funding, would that be something that we pull, or is that just an over-anxious question? I just
It's
want
a
to make
good
sure.
question. Which definition is it?
That is on the third one on the agenda, FP 2023-23.
Yes, that's the ESOL teacher.
Correct.
I can't believe that would affect. That's about the qualifications for a teacher.
And it defines English language learner. As long as that's an entirely separate section, which would not impact school money, I have no objection to consent, but I wanted to raise the question.
Your term. Yes.
This what is this doing? It's relative to the licensure standard of an ESOL teacher. And changes were proposed by the Professional Standards Board. So it's all about their licensing.
The question is, does the definition of an English language learner differ in any way from the definition that is used for school funding?
I'm unsure. I'd have to pull it back up. So
If the agency is here,
The-
I'm sorry, if the agency is here, then perhaps they could answer the question.
Yes, is there someone who can answer that question? Turn your background, please. There you go. Leno, leave the light on.
No, it went off when you hit it again.
So
There.
it's supposed to be red. Okay. Good morning, Julie Shea, Administrative Rules Coordinator for the Department of Education. That definition did not change from the last proposal, and so I would imagine that it's not going to affect anything because it was already there before, if that makes sense. The changes that were made to the proposal for the ESOL teacher did not involve the definitions, and they were already there.
You
What
mean
they
from
did
from the draft or
From the prior rules, it did change where OLS made some comments regarding how the definitions were written, because the way that we had it separated out wasn't in the proper format.
Okay, and then if that doesn't impact the funding definition, then I have no problem with consent. I just wanted to clarify that that does not expand the definition for funding.
That I don't know. All I can speak to is what was there before, and that I don't think it had any impact prior. I can either follow up, or I can ask the division director who is down the street.
Then perhaps I should pull that from consent.
Okay, we will
Thank you.
pull that from
Okay.
consent. You will
Thank you.
contact the division director to make sure there's no impact to the funding formulas. And, all right, any other questions on the consent agenda?
Is 2023-100 still on the consent agenda? If so, I would like to pull that. It is the item V in the consent calendar.
Item B is,
V. V is in Victor.
oh, Victor, thank you. I hadn't gotten that far. Yes,
Okay, I'd like to pull that from consent as well, please.
Okay. Any other, yeah, Representative Phillips, Adam Phillips?
Yeah, thank you, Mrs. Chair. I noticed a grammatical error on subsection B, which is the charter school lease aid item. It's 2023-19. Page 5, there's a small grammatical error, so I wasn't sure if that warranted being removed.
Director?
That can be corrected editorially at the
Great.
time of adoption.
Okay.
Madam Chair, move to approve consent minus the items that were pulled.
Second.
Second, okay. Seconded by
Representative Mann.
Representative Lynn, okay. Any further discussion, comments, or things to remove? Seeing none, those in favor?
Aye.
Those opposed? Okay. Moving on to the regular agenda.
The first one on the regular agenda is 2022-165. It has been withdrawn.
Yes, this rule is no longer necessary because the Allied Health Professional Office was deleted in House Bill 2, so it does not exist.
That's correct.
Okay. The professional geologists.
Okay, 2023-15 is essentially the issue is that there's a seal of the board and the board is now using a generic seal. So when a person sees the seal, it doesn't say that it's for geologists. It's just a generic PLC board, and we think that this could be confusing if somebody has a seal that doesn't identify the board it's for, and it's just a generic seal, generic OPLC board. And I know PLC is going to all generic seals kind of for everybody, but it may be confusing if you can't tell which board it's from.
If I could
Yes.
step in here. So the next proposal also has the same issue. And so the board statutes actually require the board to adopt an official seal, a design for official seal. So it's unclear. It's probably not what the legislature intended, a generic seal. They wanted a specific seal for each board. And so both in 15 and in this one, one for geologists and then the Board of Architects, like Christina said, it just says New Hampshire Board, Councils, and Commissions. So there's no indication that it's specific to either geologists or to architects. And we're seeing this a lot in the IPs. So it would be good to go ahead and figure this out.
Yes, Tina.
Good morning, Tina Kelly from the Office of Professional Licensure and Certification. OPLC takes care of all the paperwork of the boards. They process all the licenses, they do all of that. And so that having a seal for each board, I don't believe is necessary. It says in the rulemaking authority that the board will have a design an official seal. They've chosen to go with a generic seal. Any documents that are sealed would have the name of the board on it. So I don't believe it would be confusing as to which board the documents are from.
Could you explain how that happens if you've got a generic seal? How does it say this is a geologist that's stamping this document?
No, that's two different things. The geologists who have to seal their documents have their own seal. That's a different rule. This is the seal that the board say they had if we still sealed licenses, this would be that seal that would be used to seal a license like we used to do. I don't believe seals are used. We do. So they're using the generic seal. The document itself has the name of the board, but the seal, the raised seal.
Representative Grota?
Thank you. I just want to understand, make sure that I understand what you're saying. So you're saying that, let's say someone's applying for a license for architectural landscaping. Their license would have a generic seal that says that. I'm just trying to think of where you would use this generic seal versus certifying that the work is being done by someone who's certified.
I can answer that question. Lindsay Courtney, Executive Director, OPLC. So the seals are rarely used at this point since we have moved away from a paper process. They're mostly used for wall certificates when people request them, and we do use seals for wall certificates upon request. The whole purpose of this seal is really to just designate that it's an official state of New Hampshire seal, and that's the purpose. And I think a generic seal satisfies the purpose of the seal requirement in the statute. Regarding the other seals, those are entirely different and would designate, typically a license number for that professional, the profession, but it's very separate and distinct from the actual state of New Hampshire seal.
Follow up.
Thank you. So what you're saying is that if somebody asks for a wall certificate and they're an architectural landscape architect, then they would get a certificate from OPLC that has a generic seal, but it would still say somewhere on that license what the profession is.
Correct. It would say state of New Hampshire, this person authorized to practice as landscape architect, and then the seal usually at the bottom right-hand corner, I think.
And if an individual needs their seal for their work, that's something, where do they get that?
So typically that's required in a lot of technical professions. They get that on their own in accordance with the regulations established by the profession.
All right, thank you very much. I'm satisfied.
Representative Fellows?
Suppose a board wanted to support the board that covers I guess we're talking about geologists, wanted to write like some kind of official letter. You'd have them write that under the seal of OPLC in general. I'm just thinking that they would want to distinguish them, who that ruling is coming from, or request, or whatever it is.
So I'm not aware of an official letter that a board would be able to write. They'd be able to issue orders. They'd be able to issue declaratory rulings. Typically, we advise against the boards from just taking positions. That doesn't have a basis in statute. I suppose if they wanted to designate, our position is that the seal, which again, the purpose is to just make clear that it's a state of New Hampshire function, is an administrative function that falls within our statute.
That I'm not clear that I understand that. Suppose there's somebody wants to write a letter and it's part of a public hearing or something, and they're writing an opinion of the board on something, or I don't know, might be a disciplinary action. I don't know if you're the person, the OPLC takes disciplinary actions or the board does. So there's no confusion that whatever that document is coming from the board.
There is no confusion because typically there's a header that says, State of New Hampshire Board of, name your board, and then order on blah, blah, blah. Just as in court opinions, we don't seal disciplinary documents.
Senator Gray?
Like it or not, I believe that they have met their legal requirements, what we've written in the law. The objection from staff was whether there would be confusion. We've heard testimony from the department that it should not and will not. We are all able to write legislation in the coming year, and I think we've discussed this enough, and I'm ready to go on and approve it.
Thank you.
Madam Chair,
Senator
I
Lang.
move to approve 2315.
Okay, seconded by Senator Gray. Any further discussion? I'd like to say that the distinction between the board seal and the seal of the individual professionals is very important, because that's the seal that needs to say what the profession is and who the person is who's doing the official seal. So I'm glad that was brought up and clarified. Anyone else? Okay, the motion is to approve the rule of, those in favor?
Aye.
Opposed? Okay, thank you very much.
Thank you.
The Board of Architects?
That, I had no other issues other than that one.
Okay.
Excuse me, can I ask a question, please, of the chair? Are we
Yes.
saying then, therefore, we approve the removing of the seal, the generic seal?
For the board's stamping of things like wall licenses, yes.
I vote no.
Okay, thank you. Let the record reflect that Representative Grota voted no on the geologist rules. Senator Lang.
I move to approve 54.
Okay. Is there a second? Second by Senator Ennis. Any discussion, comments, or questions? Okay, seeing none. Those in favor?
Aye.
Those opposed?
No.
No. All right. Representative Grota votes no on that one also. Okay. Public Health Laboratories.
So this proposal, 2023-32, the agency did file a conditional approval that addressed all of our substantive comments except for one, and the one remaining really would need a legislative fix as it has to do with two conflicting statutes. The agency is authorized to set and administer administrative fines in the statutes. However, where that fine money goes, there's a bit of a conflict. So RSA 151-16A directs the agency to forward those fines to the state treasury, and the state treasury to put that in the general fund. However, the next statute, RSA 155-16B, directs the state treasurer, once they receive the administrative fines and civil penalties from the agency, to put that money in a separate non-lapsing interest-bearing account. So there was a question of whether the legislative intent was that there are two different types of administrative fines that'll go into two different accounts, or if the intent was to have all of the administrative fines put into one account, but which one, it's unclear. So that was the only comment I had with this particular proposal.
Sounds interesting.
Good morning. For the record, my name is Doreen Shockley. I'm the manager of the Bureau of Licensing and Certification. We would like to thank OLS attorney for discovering this inconsistency. The legislation for the second section B was enacted or effective in 2010. So the inconsistent language has existed since 2010. After receiving your comment, I consulted with one of our attorneys who agreed that there is need for clarification, and therefore we are already in the process of putting forth legislation. I think it's also worth noting that the intention was, in fact, civil money penalties, CMP penalties, are very different than the others, and we are following the intention, and one is in the general fund and one is in a separate non-lapsing recurring.
All right. So if I understand you correctly, you're saying you're working with some legislator to clarify which fines go where, but you think you understand it and have been doing so.
Correct.
Any other questions, Representative Leon?
Thank you, Madam Chair. My question is about what appears to be some expansion in scope in the licensing rules in 808.02E. It says that this is everybody who is not covered by this. It says all entities that performed wave testing for the sole purpose of risk assessment and which test results are not used for the diagnosis, treatment, monitoring or consideration to provide or continue to provide treatment of disease. The existing rule only says that are not used for diagnosis or treatment of disease. And I'm curious where there's the statutory authority to potentially greatly expand the regulation under this rule.
Not prepared for this question. Do we? No.
Ms. Shockley?
I guess I'm not really sure I understand the question.
The question is, before there was nothing that required that a lab that is only doing risk assessment and not providing diagnosis or treatment of disease. But if you say at monitoring or consideration to provide treatment, that would be any sort of early wellness testing where you might be looking at not looking at any level of clinical disease, but people looking to see what their risk factors are. And in order to decide whether or not it is necessary in order to escalate to a physician. My background as a device analyst, I did some work in laboratory and diagnostics. So the distinction may seem minutia to you, but I've seen the application.
Thank you for your question. I'm going to defer to our unit chief of the adult licensing team.
Kelly Keith, licensing unit for health facilities. Good morning. So the exemption was expanded upon on the recommendation of the CLIA coordinator, CMS, because if it's risk assessment only and they're not considering treatment or providing diagnosing opinion, then it would be for health fairs, screening, wellness, like when a hospital puts on, for employees. The intent was to avoid the burden of licensing for those type of screenings rather than treatment and diagnosing.
Do I understand correctly that this expands the type of laboratories that do not need licensing rather than the ones that do? So it may exempt some existing laboratories from licensure. Is that correct?
No, not existing, because a true laboratory who's performing and testing results for diagnosing or treatment, they need to be licensed. This is, you'll often find fairs they pop up in their transient. It could be blood pressure, it could be blood sugars, it could be cholesterol, and it's finger sticks. But by the definition of a lab, if you produce a result and you're diagnosing it, you need a license. And we agree with that. But these fairs or screenings aren't providing that type of service. What they do is they'll provide the numbers, like a blood pressure reading or a blood sugar, cholesterol, and they recommend going to your doctor.
Okay.
So, as clarification, wouldn't that be consideration that you may need treatment of disease? That when you have a high blood pressure reading, that they say you should go to your doctor and find out if you need care?
Correct.
My concern is that this is not in the inclusive part. This is the one that rules people out. It says that if it's not used for consideration to provide treatment, that it is required to be licensed, to be ruled underneath the statute. Now, it's tough because it's a negative and then it's a negative within there. So we're looking at a double negative.
Yeah, I see what you're saying for sure, and I think it's just a wording. The intent is that the results aren't used for that, but if we're wording it wrong and it's inferring that, then we want to clarify that.
Thank you. I think it would be helpful if we could go to the original language, not used for the diagnosis or treatment of disease, because that would exclude all of these screening fairs or other monitoring events.
Okay.
Yes.
Right. And
So
that's
I'm sorry.
Senator Lang.
Can you restate how you want that written? So I
yes.
understand it better.
Thank you. Yes, that way we can have the information. This is in HEP 808.02E that I would like it stated. All entities that performed waived testing for the sole purpose of risk assessment and which test results are not used for the diagnosis or treatment of disease, semicolon. Is that acceptable?
Yes, that was the old language, and we have that right here, and we can
send the official language to OLS.
Okay, thank
you.
you. That will help. Any further comments or ask Representative Leon?
Thank you. Sorry, I have another question here. In the area of noncompliance, which is in .03C, so right on the same page, that is a new area. And I saw that previously in the similar section, it did not include a requirement for state licensure to comply with other federal or state requirements. So we've seen the impact of some federal requirements that are just rules or that may not have the full backing and full strength, that this would then cause a problem where it could bring state enforcement of federal requirements, that this doesn't spell out that it needs to be a rule, it doesn't need to be a law, but is this a CDC recommendation? And I'm concerned about that scope creep.
Yeah.
Could you say that a different way? I'm sorry, because we do have the authority with there's a federal regulation, but CDC guidance, we can't enforce guidance.
Is it would that
it's
CDC
not used
guidance
for
be a
diagnosis
requirement
or
or no? Because this is replacing deficiency and it had the same definition, but this area of noncompliance adds or other federal or state requirements. And I'm just curious the implications.
Madam Chair,
Yes.
I
Director?
think because it said federal requirements, that would include federal law or federal regulations in the CFR, but nothing else.
Okay, thank you. That clarification is very helpful. So
Okay.
I'll withdraw that question. Thank you.
All right. Any other questions, comments? Okay, do we have a motion?
Move to approve as edited.
Second.
Okay, that's a conditional approval. And I'd like to add, if that's okay with you, Senator, that the department continue to work for the legislative fix on their funding issues. Or actually, I mean, where the fines,
Madam Chair, would that be a recommendation to be added to the motion?
yes.
Yes.
Thank you.
Any further discussion or comment? Okay, the motion is to conditionally accept the rules with the recommendation they get legislative fix. Those in favor?
Aye.
Opposed? All right, thank you very much. Okay.
So the next couple of proposals, the first issue that's going to be discussed will apply to not only 2023-52, but also to the three subsequent ones, so F through H. And this particular issue, as we discussed last time, has to do with the administrative processing fees versus a licensing fee. So the OPLC did submit it's amended conditional approval because their original conditional approval had just removed a fee from the plumber's table in that particular rule section. So this amended conditional approval, they have changed it from saying application related fees to application processing and licensing fees in the section title of each different section. And then with regard to the table itself, in the places where it had said application processing, they have added after that and licensing. It is our office's opinion that this doesn't really address the issue that was brought up, which is what constitutes a licensing fee versus what constitutes an application fee, as these are two very different fees. One is refundable, as it is a benefit conferred or a conditional privilege, which would be the granting of the license. And when you look at the board statutes as a whole, it's very clear that these are benefits, because the statutes, at least the ones that we have looked at so far, which primarily are the court reporters and the recreational therapists, state very clearly that you cannot practice these professions without a license, and therefore it would be a conditional privilege for you to be able to practice because you need that license. I believe our original recommendation was to just remove the application fees and just have them as licensing fees, as the OPLC was unable to tell which would be considered a license fee versus what would be considered an application fee for each of these sections. And they had mentioned that they needed these rules to go forward. So to address the issue for now, just call them licensing fees and then have them go back and reevaluate what would be considered an application fee. However, it seems that they have just added licensing to make it clear that there are two fees, but they still have not separated them.
Yes, thank you. Representative Grota and I met with the OPLC on this issue because we agree that there is in fact a license and a licensing fee, and the OPLC is unable at this time to determine how much of the fee is a application fee, which does exist, versus a licensing fee, and that they will be revising this as they deal with each individual profession, which was agreeable to us because it turns out that requests for refunds of license fees are not common. The most usual case is that someone is in the middle of an application and withdraws it, probably because I think they won't get a license. But that can be dealt with on an individual basis.
If I could just jump in, since the agency doesn't know what portion of the fee is going to be a cost recovery and not, for conditional benefit, then it really would make sense to amend these rules to indicate only that there are licensing fees until they know what portion of that fee is cost recovery. In some cases, they can probably identify it. When we get to court reporters, I can point that out for you, for the committee. Also keep in mind that there's been a lot of rulemaking over the last 8 to 12 months in which those rules were approved that say that application processing fees are non-refundable. And the agency is including licensing fees that are refundable within that. So they really need to go back and do some cleanup to those rules. So the agent, you may want to ask the agency or get the agency to commit to amending those rules that have been approved.
Good point.
Thank you, Madam Chair, members of the committee. Lindsay Courtney, Executive Director, OPLC. With me is Attorney Douglas Osterhout from the Office of Professional Licensure and Certification. I think the issue before the committee is really quite simple. It's whether OPLC has the authority to charge or assess the fees that are proposed in the PLC 1002s, and I think it's quite clear that we do. Under the newly revised statute or recodification of OPLC statute, which is 310.5, the executive director of the office shall establish and collect all license, certification, and renewal fees, as well as any necessary administrative fees. I know counsel for OLS did acknowledge in the court reporter's filings that the application fees can be considered an administrative fee. So clearly there is authority to charge the proposed fees. Now, with respect to the application versus licensing fee distinction, I'm not sure that there is a distinction. And I think that the materials cited by OLS in the email that we received, that's part of your package, really explain that you have to look at the substance of what the fee is actually doing and not just the language that's being used. We would actually dispute that any of our fees are for a benefit conferred. I don't think that you get a benefit from having to be required to actually obtain permission from the government to perform an occupation. This legislature has stated in statute that the right to pursue an occupation is a fundamental right. And I think using the title, the prohibition on using the title of court reporter is really intended for a consumer protection issue to make sure that the public understands who's licensed and who's not. Now, when we talk about cost recovery, the materials cited by OLS talk about a cost recovery, a true fee, which is not refundable. To be considered a fee, the amount paid to acquire, quote, a business license must bear a relationship to and approximate the expense of issuing the license and of inspecting and regulating the business license. I think it's clear that all of OPLC's fees support the regulation of the profession, particularly now, thanks to Senator Lang and the legislature, that we have a non-lapsing fund. Everything goes to support the OPLC regulation. So I guess in sum, I think we have the authority. I think all of our fees are cost recovery. It doesn't really matter what you call it because that's what's happening. And I would submit that the fees are very reasonable in light of the fact that the majority of the fees have been in existence for years.
And if I may just quickly jump in, it never was an issue of whether or not they had the authority. It's very clear that they have the authority to collect these types of fees. We're not arguing that. What we're arguing is, as Director Courtney pointed out, we see there's a distinction between these fees, which the OPSC doesn't agree with. And if that continues to be an issue and if that is a concern for the committee, then perhaps legislation can come forward to clarify exactly what type of fee is what or what was intended.
The issue is, she just said, is not whether they have the authority. They do. They can assess fees. It's what type of fee did the legislature authorize? And it's pretty clear there are two types of fees. There are administrative or cost recovery, and then there are license fees, and that is for a conditional privilege. So, in the court reporter statute, it's pretty clear that it is, you can only practice. You can only have that title if you pay and you have a license. So there is also an application fee that's listed in the statute, but they are different.
I believe the significant point is that a license fee is refundable and an application fee is not. And the point the OPLC is making is that the license part of the fee is vanishingly small compared to the cost recovery part, of which they consider an application fee.
Well, they can certainly be transparent with that in their rules, and they're not doing that now.
Thank you. Yes, Senator Representative Lynn?
Yeah, I guess I have to say, I agree completely with the OPLC here. I think we're making this much more complicated than it needs to be. I mean, as I understand it, correct me if I'm wrong on this, but first of all, on the issue of a conditional privilege, I mean, I guess it's not clear to me what license, if the law requires you to have a license to do whatever the business is, presumably, if you can't practice the business without the license. So I'm not sure that, trying to draw distinctions between one type of license or another makes sense. But the other thing I'm really concerned about is certainly the legislature, if it wanted to, could draw distinctions between application fees and license fees and say that one is refundable and the other is not. I don't have any question that the legislature could do that. But as I understand it, the legislature hasn't done that unless there's some particular statute that I'm overlooking, but the legislature hasn't done that. They've just sort of said, you can collect, they've used language like, application, license fees, administrative fees, those kind of things, without really indicating that they intended to distinguish between those.
Some of the professions do, each board is different. That's one of the issues we have. And some of them do make distinctions between application fees and license fees, but that's not all of them by any means. And the other issue is that there are some professions where the initial licensure fee is significantly higher than the renewal fee, which indicates that there's a major application processing part of it that needs to be done once, but not again.
Yeah, you're
Director
correct.
Morrell.
Historically speaking, the committee and staff have always thought of a fee for a license, for the issuance of a license, is refundable if the license is not issued. Where it says an application fee, it doesn't talk about a license fee. If it says solely an application fee, then that is non-refundable. This situation is a little more difficult because there are a number of different statutes with the different boards. Some say application, some say license. I think the office is trying to make things clearer and more uniform, but I think it may need statutory changes. I also think there's a little confusion here in these rules because there's reference to administrative fees. I mean, personally, from the history I've seen of the boards and their statutes, an administrative fee was only intended to be minor administrative costs, like a licensee loses its wall certificate or it's damaged and they want a new one. So there's a $10 fee for that. In the past, people have been able to get a list of licensees from a particular board there may be a fee for processing that. I think now it seems with these rules that the dimensions of administrative fees seems to be expanding.
And throughout these proposals, it indicates that these fees are non-refundable, period, and that does include license fees.
May I just ask one follow-up question? Can I just make, am I understanding, is there now in some of these licensing statutes, is there specifically, has the legislature said these fees are refundable? Has the legislature used that language in some licensing statute?
I'm not certain, not that I know of.
No. And I think that's the issue, because I could find no authority for the proposition that license fees are refundable and application fees are not. And I think the materials cited by OLS support the proposition, and I'm quoting from the memo, when evaluating a revenue law, the substance controls and not the labels. So this oversimplistic distinction between license fees and application fees really has no bearing on whether or not it's refundable or not. I think you have to undertake the analysis of the cost recovery versus conditional privilege. And our position is that everything that we do is cost recovery because everything supports the regulation of the profession. Now, some may be more towards the application processing itself versus the regulation, which would include assistance with rulemaking, assistance with investigative support. And I do think that we can do a much better job of distinguishing, how much is going to what type of function. That it absolutely we could do a better job. And after we, continue to assess costs and allocate them, but I don't think that I just disagree with the simplified distinction between license fees and application fees.
I was going to say there's only one other section.
Representative Broda.
Thank you. So this year, the legislation of surrounding House Bill 655 was that OPLC was going to have jurisdiction over setting fees. So I'm thinking that there's no conflict in any of the board statutes, and that HB 655 as amended overrode or repealed all the authority that boards have for setting fees.
I believe I have some comments from the staff on that one.
I just am a little confused, actually. I'm not sure how a person that is reading the rules would know what fee is refundable and what fee is not refundable. How would they know that if you don't tell them which fee is refundable and which fee is not?
We do. It's in the PLC 300s. We state explicitly that you have to look at the 1002s to determine what the fee and that the fee is non-refundable.
Madam Chair, if I just, because I was just a preamble to what I was going to say. Okay. So if that's the case, then I think that, and the reason for centralizing the licensing process, whether it be the fees, was to give a more efficient and effective way of dealing with licensing. And therefore, I think that warrants an examination as to how licenses are processed and what part of the fee is refundable and what part is not. And I think because we've brought in this new statute, I think it requires us, because this is a different way of doing things. It requires us to come up with as efficient or effective way of handling licensing or administration fees. And maybe what we're saying is that because OPLC takes on the burden of responsibility when it issues a license, because it is looking at different components of the requirements of these licenses, they take the burden on, and therefore that is where the main portion of fees are found or lie.
Okay, Director Morrow.
We have no issue that the Office of Professional Licensure and Certification has authority to impose fees. That's not a question. The question is, what type of fee is it? And do they have authority to say it's non-refundable?
Okay, and I agree that we need to be more transparent about this, but I'm not sure that the OPLC is able to do that at this point in time for all the professions that are listed in this rule.
It certainly would be,
And for all those reasons, I think that the legislative solution is what we need to this, and it's not going to happen this year, and therefore I move the item.
Second.
Okay, moved by Senator Gray, seconded by Senator Lang. Any other comments, questions? I'd like to add a condition that the OPLC continue to work on clarifying their fees.
Condition is acceptable to my motion.
Okay. We'll just so you don't get bored and idle.
Oh, good. I was worried.
And does that include the previous rules that have been passed that indicate that all fees are non-refundable?
Yes, if they look at those rules and decide that that their first pass was overly broad, then yes, they should go back and fix them as necessary. Director Morrell?
I assume your addition is either a recommendation or
recommendation.
An understanding.
Yes, a recommendation. Any other comments, questions? All right, seeing none, the motion is to approve the rule with the recommendation that the OPLC work on transparency. Those in favor?
Aye.
Opposed?
No.
That was
Senator Chandler, I think.
Yeah. Senator Chandler. All right, thank you. Okay. Recreational therapists.
So we got one big issue out of the way already, but and now another one that I'm sure the OPLC is very happy to talk about again, which is the retention policy that we have brought up before. So I won't get into what has been said before. What I do want to bring up is that in looking at HB 655, there was language added in 4 places that require the OPLC to retain records in accordance with the retention policy developed by the agency, but it does not state that it needs to be filed with the Secretary of State. As I know, that was an issue that the Secretary of State, specifically the Director of Archives, does not have rules with regard to retention policies. And what our office's concern is that this affects the licensees or anyone else who is looking for these records. So it affects the public at large. So it should really be in rules somewhere to ensure that this is being applied even to all people evenly, all boards evenly. Additionally, RSA 541A, as the committee may be aware, specifically states that, you know, if it is a rule, it needs to be written as a rule unless it is specifically exempt in statute, which we do not see an exemption in the statutes here. There is also case law in New Hampshire that specifically states that policies are not enforceable. The public cannot enforce the agency cannot enforce it as it is just an internal policy as opposed to a rule. So we would once again argue that this retention policy should be written as a rule, and based on what we're seeing in HB 655, that the OPLC should probably put those in rules themselves, and therefore would recommend that the committee consider potentially a petition for rulemaking regarding this issue.
Director Morrell?
Historically, most agencies, the boards, have had rules that say, for example, the board shall retain all records for 3 years unless otherwise established by the Director of Archives pursuant to RSA 5:30, where he or she does have the authority to establish requirements regarding record retention. I mean, the director could say, I want all agencies to retain records for 5 years. It's not necessarily submitting those records to the Director of Archives, but at least completing them. As was indicated in this instance, there is no requirement for a specific time or how to retain the records. The records are simply being held pursuant to an outside document by the agency.
But if I understand correctly, the issue is that the Director of Archives has the authority to write rules on this and has not yet done so.
Yes, I spoke with the Secretary of State yesterday morning. He indicated a willingness to meet and talk with that. In fact, have a meeting with staff and OPLC if they wish to discuss the issue. But you are absolutely correct that for decades, the Director of Archives has not had rules on this. And if the committee wished, it could petition for such rules.
Director Lindsay?
Thank you. For the record, Lindsay Courtney, Executive Director, OPLC. So this is a carryover language from what was in 310A that was added, I believe, 1 or 2 legislative sessions ago. And in drafting it, we purposely did not state in accordance with the rules adopted by 541A because we believe that the rulemaking authority actually lies with the Secretary of State. And so we did follow the process, even though it's not in rule. It took us over a year to get approval from the Secretary of State. And we did adopt in a policy what was approved by the Secretary of State's office, and specifically by archives. So I'm happy to put this into rule, but I do think that that conflicts with their authority. And I think if there is a petition for rulemaking, it really should lie with the Secretary of State and not with the office.
Since you have a document from the Secretary of State that you're using, can you include that as a incorporate by reference the guidance from the Secretary of State? Because like that might, it's not their document, it's the Secretary of State's document.
We can make it part of the record for this rulemaking, but it's not something that can be, at this point, be included as incorporation by reference.
Okay. Because it seems to me that that's really, they're referring to the guidance they have been given by the agency that has authority over that area. So I don't think we want the OPLC to make rules on this issue.
Yeah, my concern is that such a letter from the Secretary of State telling or indicating to OPLC this is how you should keep your records. Well, the keeping of those records by OPLC, I would say constitutes a rule because it affects people outside. And they may have their own requirements. I mean, it should be someplace incorporated in a document that everyone can see.
Senator?
Thank you. So again, my concern is we get into the same problem we had at OPLC where boards had rights to make rules and then the agency had right to make rules and the rules were conflicting. So my concern is that if the agency adopts rules that then goes and conflicts with the archivist rules, then we have, you know, a constitutional issue, which one is the overriding regulation. So I'm not sure we're talking to the right person. And that I think it's the archivist that has the responsibility for setting the retention rules for the state, and then the agency would be required to follow that rule for retention. So I think we're kind of yelling at the wrong person. In the short term, I think the director has corrected it by creating an internal policy until the rules are adopted. And I think they've followed the right process. So I'm going to make a recommendation to approve.
Okay. Representative Fellows?
My concern was along the same general line as what Senator Lang just said, that the retention policy is not necessarily driven just by what the archivist says. It has to do with, I think it needs to have to do with like what the material that you're dealing with. For example, in education, schools are responsible to keep enrollment information in perpetuity. So, and if you have federal grants, there's a requirement that you keep certain pieces of information for a certain length of time. And then, of course, anything that with licensing, there could be lawsuits. So you wanted, I would think, statute of limitations would apply. So it's not like all of your information. It can be some of your information, and the retention policy could be different for different pieces of it. I don't think this whole issue doesn't lie just with the archivists.
If I may, Madam Chair,
Please.
the policy that was approved by Archives is on our website and does describe the different types of documents and have different types of retention schedules based on the documents.
And that information is in fact available to the public.
Yes, it's on our website.
Okay. Further comments?
There's a motion and a second.
Okay. There are no more discussion, then the motion is to approve the rule. Those in favor?
Aye.
Opposed? All right. Thank you very much.
Okay, court reporters. We've already talked about the cost recovery versus license fee, so I won't talk about that. However, the fees do not match. The fees in this proposal say $155 for initial reinstatement and renewal. That's a piece. But the rules that you've just approved previously for 2023-52 say $300 for initial and reinstatement fees, $200 for renewal. So so that's a problem that the fees do not match in this proposal. Second, there is, just to point out to you, there is a $100 difference between the initial and reinstatement fee of $300 to the $200 for renewal. So in this instance, perhaps as you stated, Chairwoman McGuire, the cost recovery may be $100 difference. And so this proposal and the rules that you just approved in 52 could probably be amended to reflect that. There's another issue, and we've already talked about it, the retention schedule, so I won't spend any time on that. The next issue to bring to your attention is there are some statutory conflicts that will need to be addressed in the next session, and that's around the term of licenses. And we're seeing it a lot with a lot of the initial proposals that are coming in. So the OPLC statute conflicts with the board statutes. The board statutes generally say that the licenses expire during the licensee's birth month, but the OPLC statute states that it expires during the month of issuance. So that's probably going to be confusing for some licensees. They do have a notification on their website about it, but the committee may want to know what outreach has been done beyond that notification so that licensees aren't taken by surprise. And then lastly, the link in the appendix is not accurate. So, but that can be fixed at adoption. And that's all I have.
Madam
All right.
Chair,
Yes, Director Moore.
since Senator Ward has left, would you like to appoint somebody to replace him?
Representative Hacken Phillips can sit in for Senator Ward. Okay. Yes.
Thank you. I think there are two issues here. The first, regarding the statutory conflicts, we are very aware of the statutory conflicts. This is part of what will hopefully be another cleanup effort in the next legislative session regarding the terms. With 655's passing, I believe it makes clear that all licenses are slated to expire 2 years after the date of issuance. The way we've implemented this is forward thinking, obviously not changing existing dates, but changing them as they are issued. So upon renewal, if they have always renewed on their birthday, assuming they renew on time, they will continue to always renew on their birthday because the last date of issuance is their birthday. In terms of communications to the public, we did send out an email blast. We also have posted this information, I believe, on every board webpage, and we really haven't gotten a lot of inquiries or individuals confused about that. With respect to the first issue with the fees, honestly, I take responsibility for this one. What we had intended to do with the PLC 1002s is really not change or deviate from existing fees at all, because what we were trying to do is just get all the fees into one document so we can avoid this whole Every board adopts a fee. The prior fees for the court reporters when we started working on this were 300 and 200. The 300, I believe, was set in statute, and so that's why that was included. But if you may recall, 2 years ago, I had presented some fees for the board's consideration that didn't go anywhere. It ended up becoming part of a discussion with the SB 330 committee. But we had recommended modifying the fee for court reporters to 155. So what I would suggest is that this rule really should just point to the PLC 1002s, and to the extent that anything needs to be modified in the future, that we will make those modifications in the 1002s.
So just to be clear, the fee is 155, and will you be amending the rule set that was just approved in 2023-52 to indicate a 155 fee? Because currently it says 300 and 200.
So I believe this proposal should be amended to reflect that we are utilizing the fees set forth in the PLC 1002s. The PLC 1002s, I believe, were just approved and include a fee for 300, 200.
Exactly.
Which has always been the fee for court reporters. We will obviously need to re-amend the PLC 1002s after undertaking additional analysis. But I suspect that those fees will significantly be decreased.
Representative Grota, you had a question? No, okay. Anyone? Senator Lang.
So are you suggesting that in this one, in 12.4.2, where it says applying for initial license, section 3, that says 155, we should strike number 3, or have it just reference 102, the other statute we just, and that would be the amendment you would agree to?
Exactly. Reference the 1002s, pay the fee as described in 1002 or something to that effect.
All right, we'll have some people bouncing around looking for the rules, so I hope they're obvious.
Move to approve as amended, or conditional approval as
Okay,
amended.
seconded by Senator Chandler, I believe. Nope.
Senator Ennis.
Senator Ennis. All right. Any further comments, questions, or discussion? Okay, those in favor?
Aye.
Opposed? No. Senator Chandler says votes no. Okay. And if there is in fact a statutory fee that we want to add that to the list of things we need to take a look at. Okay, any Board of Podiatry?
So this one has the exact same comment about the licensing, and that's the only issue that's on it.
Senator Lang.
So
Tim.
given that we already had discussion ad nauseum on that, I move to approve.
Second by Representative Lynn. Any comments, questions, discussion? Okay, seeing none, those in favor?
Aye.
Opposed? No. Okay, Senator Chandler votes. All right. SNAP definitions.
Madam Chairman,
Yes.
just for the record, I believe that Senator Lang's motion included conditionally approving the rule to make the same insertion as in the previous rule.
I'm sorry, Madam Chair.
Please.
So the motion was to deal with the adoption, to change at number 3 to say the fees were set by 1002, rather than have the fee in the rule.
Exactly.
Thank you.
Okay.
Okay, the only issue on this one is actually that there were a couple definitions that expired in 2006.
Good morning, Nicole Valenzola, Administrative Rules Coordinator for the Department of Health and Human Services. Madam Chair, actually, if I can bring some clarification to this. Previously, the area agency had sectioned out their definitions in a specific formatting where each section 0.01, 0.02 was a different word. They are now reformatting and clumping definitions based upon, alphabet. So the section was a previous word that is no longer utilized and hasn't been used, and so the section was reserved. But per AARL language, we have to write expired, but there isn't actually expired language, and the words that are now in that section are new terms to be defined. So the previous word that was 0.02 is cash account, and that term isn't used any longer, and the new term now is, I think they're using EBT in its place.
So you're saying that the definitions that expired in 2006 are no longer used as such?
Correct. It was one word in that section that hasn't been used.
Okay, well, if you're not using it, I guess it doesn't matter if it's expired.
It's been reserved. I don't know for how long that section, so.
Indefinitely, as far as I know.
So we might have shot ourselves there in the foot by even saying it was expired, but that's my fault.
Okay. That's the only issue?
Move to approve.
Okay.
And then, Madam Chair, I don't know, I had one that was pulled off consent while I'm up here, or I'm happy to go back and sit and wait if you wanted.
Vote on this one first.
Oh, I'm sorry.
One at a time. Yeah, I think we'll deal with the ones off consent last. That's the usual procedure. All right, do we have a motion?
I already moved to approve.
Oh, send it.
Seconded.
It has been moved and moved and seconded to approve the rule. Any further discussion, comments? Seeing none, those in favor?
Aye.
Opposed? Okay,
Thank
you
you.
very
Sorry for that
much.
interruption.
So the next is 2023-6. It's an expedited revision to form. There are two comments on this particular proposal. One's an unclear and one is simply a note to the committee. Both have to do with the fact that this this form was just amended back in 2022 through the same process, the expedited revision of form process. And in the notice, the second change, it says that it's changing the requirement from U.S. citizen to legal resident by the agency. I could not see that those federal regulations had been amended recently, so I was not sure why this change was happening now as opposed to 2022. And the other issue was, as I said, it's a note to JLCAR because it's not a grounds for objection. However, if the committee feels that this needs to be addressed, they can certainly do a petition for rulemaking. But the form, after it was amended in 2022, the rule text was not updated to reflect the new name of the form and the new edition date. As you can see from this rule, this proposal, there are two rule sections where this form is referenced, and both of them have the old name of the form with the old edition date.
Yes, please.
Good morning, Allison Radmay, Administrator for the Administrative Rules Unit of the Department of Health and Human Services.
Deirdre Dunn Tierney, Bureau Chief for Family Centered Services.
Okay, I'm going to address the note to JLCAR with respect to the inconsistency of the form title and edition date in the rule text on the GenCourt website. I was no part involved in the 2022 revisions. However, after looking through the records in our office, it has come to our conclusion that we have not received the proofing copy that allows us to make those changes on the actual rule text on the GenCourt website. And we did make sure we did not miss that. So that's why that is outstanding. And we'll
Director Morrell, isn't this something that the process for expedited forms is supposed to include, that you update the reference?
In the rule itself?
Yes.
If there's no substantive change, then that can be done editorially. If there's a substantive change created by the revision to the form, then they also have to go through rulemaking for the text of the rule.
I see. So in both cases, there is in fact a substantive change.
In this instance, yes, then they would need regular rulemaking.
Okay, thank you.
Regarding the question about the federal requirement, it wasn't a change in the federal requirement, it's a clarification. It refers to 42 USC 13950, which is part of the Medicaid requirements. The Social Security Act references that individuals served must also meet the requirements for that. And because the requirements include U.S. citizen or a legal resident alien, an alien lawfully admitted for permanent residence, given the space we had available on the form, we felt that using a legal resident of the United States would cover both of those, which is why we chose that phrase.
Questions? Comments? Representative Leon and then Representative Land.
Thank you, Madam Chair. I'm trying to understand, you said that it needs to comply with the Social Security Administration. It sounds like the Social Security Administration is a broader application than what this rule is? Than the other requirements. Is that correct? That you're broadening it to fit with the Social Security Administration?
So the Title V funds that are used to support the services provided under this rule are issued and allocated under the Social Security Act. When we reviewed the act to make sure that we were meeting all of the requirements in our application, it referenced also being in compliance with these Medicaid rules. When we cross-referenced those, that's when we found that language. So it's not that we're broadening it. I think we're just clarifying it.
Representative Lynn.
Yeah, you know what, I understand what you're saying, and my only concern is, I certainly agree that a legal resident includes a citizen, but I'm wondering if that term, you know, if, in other words, if I just saw the term legal, somebody that maybe has some knowledge, and if I just saw the term legal resident, I might wonder if that includes a citizen, even though I agree it does. I mean, it just seems like, wouldn't it be, in terms of sort of public understanding, wouldn't it be better to use both terms, a U.S. citizen or legal resident?
That's fine.
That's
Just
just a suggestion.
Okay. Other comments or questions?
Madam Chair,
Yes.
because this is an expedited revision to form, I don't think you can do a conditional approval.
That's correct.
You either have to deny or approve as is.
Then I withdraw my.
Okay.
Let's just.
Do you have a
approve it.
motion to approve? then?
Yes, I move to approve.
Okay, Representative Lynn moves to approve. I'll second with the addition of a request for rulemaking to update the references in the rules that refer to this form.
Can I actually clarify that with you guys? During the certification process, once we put a form revision forward, can't we amend the title and the edition date as part of the certification process? If there's no other changes in the actual rule text itself?
It would probably be editorial, but I think we would have to look
Because
at
I feel like
this-
that's how we've always done it. So I'm just kind of confused.
Well, if there is a policy change, then we would want you to update the rules that refer to this form. And you're saying there is not a policy change? You're just-
No.
So there's no change in the form that would require complementary rulemaking.
No, not other than the rule title and the edition date.
And if I may,
I mean, the form title.
I believe this form is incorporated by reference. Is that
Correct,
correct? So there's
yes.
there's
Yes.
nothing in the rule text that needs to be amended except for the title and the edition.
Correct.
Okay, so that could be an editorial change?
Yes.
Okay, then I withdraw the request and just second the motion.
Thank you.
Any further discussion, comments, questions? Okay, those in favor?
Aye.
Opposed? All right, thank you very much.
Thank you.
All right, the next one is the objection response for 2022-241 case management agencies. So I have reviewed the agency's objection response, and I do believe that they have complied with the federal statute. And they did take into consideration stakeholder testimony. However, there are actually a few typos that I would like to go over. There some of them are definitely typos that should be dealt with. So on page 9, the letter K, it refers to it refers you from K to K, and it should be J, which is the statute or the rule above it, and that can be a little confusing. On page on page 14, they're missing an S in 6A. That's not that big a deal, but on page 15, I'm sorry, page 18, 15A, it talks about they should triple the original fine, but there aren't any requirements for making the fine less in the section above. And so I don't know if they're actually changing. There's no way for them to change the fine above in any way. So that's just a little confusing there. And they're missing a line space. Sorry. And then page 21, they have an extra and. And there's one more I thought there was. Oh yeah, and then page 25, again, they have a paragraph H that they're referred to paragraph H and they mean G. On page 26, they're referring to K and they mean J. And then they have a wrong citation, the G on number 3. K3, they're referring to G3 and it's actually F3. So some of those need to be fixed just because.
So these are generally editorial.
Yes, they could do those editorially. But those were the only issues I found. Like they appear to be complying with the federal statute. And like I said, they did take into consideration the concerns from stakeholders.
Okay, we have a request for public testimony, so Mr. Clegg.
Thank you, Madam Chair. For the record, my name is Robert Clegg, and I'm representing Granite State Case Management. We're here to talk about the letter that
Excuse
you-
me,
I'm sorry.
Representative Schmidt.
So we don't have steno today. So this is the record. So you got to be really talking into the microphone. So the record writer will have even a chance at getting this down. So thank you.
Thank you. Again, for the record, my name is Robert Clegg. I'm here representing Granite Case Management. And we're here in response to the letter that came from the Department of Health and Human Services. And I want to clarify a few things. One, we had always thought from the beginning that we were talking about case management agencies because that's what was on the rule. However, we see here that they consider case management agencies to include hospitals, nursing homes, home health agencies, assisted living facilities, residential rehabilitation, residential psychiatric treatment, substance abuse disorder, residential facilities, non-emergency walk-in care centers, ambulatory surgical centers, end-stage renal dialysis centers, community residents, adult daycare centers, and hospice care. We didn't agree until we saw it here. We agree now because we understand that there's parity in the rates, and the rates paid to the hospitals for those services exceed what we get. So we'll be doing a right to know to make sure that everybody's treated equally. However, the problem that we have is that the rule that they're trying to do is not proper. They're saying that there is no CMS intervention in rules, and there is. CMS has a rule that says if you have case management licensing, everybody has to be licensed. You can't go willy-nilly and decide, oh, yes for this one and no for that one. It's either everybody or nobody. We also want you to understand what a case management does. Case management doesn't just say to a patient, here's what you're going to do. In fact, one of the reasons that we've always had a problem with area agencies is when you're the one providing the service, and then you're the one that determines whether or not you provided that service correctly, it seems to be a problem. Case management agencies such as Granite State Case Management has always been the one that says to the state, the client doesn't need that service. And a lot of times they say, you're being billed for service that the client's not receiving. So it's actually the eyes and the ears of the state and helps to keep us from paying for things that are never done. It also stops a patient or a client from not getting the services that they absolutely positively need. Now, we also see that they say that New Hampshire is under a new plan of correction. Yeah, it's the same plan of correction that they've been trying to do, and the legislature, bill after bill, in the last 2 years, has said no to. And we find it insulting that day before you're out of session, they put in an emergency rule. And for the record, I know that an emergency rule becomes the law, whether you like it or I like it. So basically, it's another usurpation of the legislative prerogative of how to run things. We have shown up every single time the legislature has asked us to comment. We show up at this committee to make sure that everybody understands how we feel. And we feel, again, insulted, only one person showed up. Well, you know, we have work to do too. We showed up at Jelcar. It doesn't take all of us, it just takes some of us to let you understand where we are. And where we are right now is Jelcar needs to somehow find a way to stop the Department of Health and Human Services from creating constant law, even after the legislature says no to what they're doing. We're going to assist by filing something next year that says if you can't get Jelcar to say yes, it's a no. There has to be some kind of legislative oversight, and they should not be allowed to wait till the last minute and say, yeah, thanks a lot. I was here in '94, and I remember what they used to say. They used to say, fine, we'll wait till you go home in the summer and we'll do it in rule. And for years, we stopped them from doing that. And what I see now is I see an arrogance that basically says to the Jelcar Committee and the entire legislature, we don't really care what you think. You may be elected, but we're the bureaucrats and we're going to do it anyways. So I'm asking you to not approve this rule. I understand it's going to go through whether we like it or not, because you can't even stop that. But we need to say no. And we'll be back again in January and we'll fight again. But we're asking for your help. And we're asking for you to act as the elected representatives. Thank you.
I'm not familiar with any legislative attempt to deal with it this year. Could you clarify what part of this you think is against legislative intent?
Well, there's been numerous bills. Senate Bill 333 talked about licensing. We've had the argument in the committees, and I don't remember which committee in the Senate and the House they were, but the legislature decided that we were correct. The legislature has consistently agreed that CMS does have the ability to say if you license one, you have to license all. I'll stand corrected if it wasn't Senate Bill 333, but it was a bill this year that we put in that you have to be licensed. So we've covered ourselves constantly.
So who needs to be licensed?
Anybody in case management needs to be licensed, everybody. It's either that or nobody is licensed, but the law requires that anybody providing case management needs to be licensed.
And this rule apparently says that if you're licensed as a hospital, you can do case management on the side. Is that the issue that you're dealing with?
According to what DHHS is saying, all of these people are doing case management, and we don't believe they are. Do you want to pitch in? Go ahead.
No, I would agree. I mean,
Please
that's
introduce yourself.
I apologize. I'm Emily Johnson. I'm with Granite Case Management. Thanks for hearing me this morning. Yeah, I don't have much clarification, honestly.
Yes.
The emergency rule, which is listed.
This is not the emergency rule,
No,
incidentally.
this
We
is not.
understand that.
This is the general rule on case management agencies.
And I believe the emergency rule does require everyone to be not licensed, but right. It's not just going to be the area agencies. It's anyone providing services.
There is Carolyn Virtue Granite Case Management. There is a statute, I believe it's RSA 151E:B1, but I may have that citation off, that requires licensure of case management agencies. Beginning on July 1st through yesterday, the department has enrolled over 30 individuals or entities to deliver case management. 2 of them are licensed. CMS requires that if state law or rule requires licensure, that in order to enroll a provider, the department must verify that that licensure exists. The department did not do that. They are not licensing providers as required by statute. And they're trying to have an exemption in this rule, but there's no statutory basis for it. Thank you.
Director Morrell.
I just want to let everyone know, the committee and the public, that this is an objection response. So the committee has the choice of approving the rule, entering a final objection and/or joint resolution, and that's basically it, unless the agency requests a revised objection. And any further basis for objection has to be based on what the committee's objection was to the final proposal.
Which
There
was?
There was in part, well, there were staff annotations and there were legislative intent to the extent that the rules were unclear. but not to conflicting with statute.
So does this rule conflict with the statute?
I do not believe that it does, but I think that the agency may be able to explain it a little bit better.
And to qualify what I just said, yes, if the agency, in changing the language in the objection response from the final proposal, create a new basis for objection, then certainly the committee can take that into consideration.
Okay.
We done?
I think so, unless there's any questions.
Well,
We will hear from the agency next. Are there any questions for Mr. Clegg? No? Okay, thank you.
Ask one question.
Yes.
Bob, can you come back? So having read what the agencies refiled after our original objection, does the same situation still exist where we're dealing with agencies providing care also saying that they're providing care properly and does that problem still exist?
That's been something that they're trying to do. It still exists, yes.
Thank you.
I want to clarify what I said, though. You have to understand that the Department of Health and Human Services, I'm sorry, Peter. Department of Health and Human Services continuously tries to say to CMS that there are no licensed case managers with conflict-free abilities in the state of New Hampshire. Now, there are 2 with over 40 years' experience. So while they keep telling the federal government we don't exist, we do.
Thank you.
I would like, may I ask?
Representative Grote?
Thank you. I would like clarification on that Senate bill number because Senate Bill 333 does concern case management, but it was passed by the House and the Senate. So I don't really understand your concern about the intent.
We amended out the parts that they have in here. We amended out the ability for them to allow unlicensed people. And there was another bill as well. It's been a fight for 4 years.
Representative Lamb?
Thank you, Madam Chair. My question is regarding the section that is deleted in this response. It was deleted section F, which exempted all entities who provide service coordination to individuals receiving developmental disability services or acquired brain disorders. By making that deletion, is this moving further away from parity among providers for licensing in regard to the CMS requirements?
I would personally say yes.
Thank you.
Okay. Other questions? Thank you very much. We'd like to hear from the
Thank you.
agency.
For the record, my name is Doreen Shockley. I'm the manager at the Bureau of Licensing and Certification at the Department of Health and Human Services. RSA 151:2. Do you want me to just respond, or did you have specific questions, or how
Please
do we want to do
respond
this?
first, and then
Okay.
I'm sure we'll have other questions.
There was a lot of information there, so I'll do my very best. RSA 151:2-B describes home health care provider and individual home care service provider means
Against directions to somewhere.
Senator?
I'll be happy to go.
Not yet, please.
Okay. Means any organization, business entity, or subdivision thereof, including a case management agency, whether public or private, whether operated for profit or not, which is engaged in arranging or providing directly or through contract arrangement one or more of the following: nursing services, home health aid services, or other therapeutic and related services, which may include, but shall not be limited to, physical and occupational therapy, speech pathology, nutritional services, medical social services, personal care services, and homemaker services, which may be of a preventive, therapeutic, rehabilitative, health guidance, or supportive nature to persons in their places of residence. HEP 819 defines home health care agency. Why am I not? I'm sorry. Case management agency means an organization in consultation with the client in the client's place of residence arranges for and coordinates the delivery of care and services to meet the physical, emotional, medical, nursing, financial, legal, and social services needs of the client. The first objection was to remove F from the scope of work, which is what we did. And that's what we're responding to. In the testimony prior to me, it was asserted that the Department of Health and Human Services considers hospitals, nursing homes, home health agencies, assisted living facilities. The reason that we exempt these facilities, they are already licensed and regulated in the state of New Hampshire. So if we are asking now for every single licensed agency to be licensed for every service they provide, you now will have hospitals, nursing homes, assisted living facilities having more than one license and having a lot of visits from us. And also, in our opinion, and has been a long-standing policy or in the state of New Hampshire, is not to overregulate individuals. Rather, we review all of the services and programs for each licensed facility. To the point,
So if I understand you correctly, your interpretation of the license all or none is that these individuals are licensed as, say, a home a hospital, and case management is one of their license functions.
and they have a lab, and they don't need a lab license.
Thank
So
you.
hospitals would need many licenses for all the services they provide, as would nursing homes, as would assisted living facilities.
Thank you. Representative Leon and then Senator Lang.
Thank you, Madam Chair. That is very helpful. RSA 151:2-B is not referenced in this rule. However, it says all licensed healthcare entities. Would it help to clarify that the RSA that facilities with case management agencies licensed under 151:2B are exempted? Would that better clarify this? Because I see what
Okay,
you're
I see
saying,
what
but
you're
I don't
saying.
see it in
Okay.
the rule.
Okay, so all licensed healthcare entities licensed pursuant to RSA 151:2-B, is that what you're suggesting?
I'm afraid that I might kick something out as well, but
Okay.
if you included one, you have all licenses.
Yes.
A is all facilities listed in RSA 151:2, comma 2A through I. But if you added one that includes all facilities listed, all facilities providing case management licensed under 151:2-B, that would make sure that all of those groups do not need to pursue another license, but we're clarifying that anybody who falls within that is exempt from this case management license.
So providing other services that require licensure, so we'd have to go back and take a look at that too, but I think we could probably make a clarification on that.
Okay.
I appreciate that.
I think that'd help a lot. Thank you.
Okay.
Senator Lang?
So I guess my stumbling block here is the fact that while I recognize they have a specific license that's more of a global license that deals with it, my question is there anywhere else in rules that requires to make sure that they also follow these guidelines for or the guidelines for case management agencies? Is there something that says that while you have a license that's up here, you also have to make sure you're following these rules? Because basically I don't want the fox guarding the hen house, right?
Right.
Without some sort of regulation that deals with that. And to a certain extent, that's my concern, right? Is that
Right.
I want to make sure that, yeah, you may be able to allow to provide case management services because
Mhm.
of your global license, but understand there's some firewall rules you have to deal with to make sure that the auditing and all of the work is
Most
done
definitely.
properly. And
Um,
is that in place?
Yes, thank you for your question and your comments. And yes, all of our rules, like a hospital is a good example, but also, I mean, they're also CMS certified and or accredited from different accrediting agencies, so they have a great deal of oversight. But they, the hospital rules also talk to all of the different types of services, radiology, cardiology, I mean, all of the services they provide and what quality measures are in place to ensure that patients are safe and healthy. Yes. Does that answer your question?
I'm not sure. My
Okay.
concern is, well, I understand there may be federal regulation. We're talking about state regulation
Yes.
relative to case management services. And so my question again is, do they have to abide by the same same state requirements because they hold that larger license and that a smaller agency that may only do case management services also has to abide by to make sure that there's that firewall of services, that there's not cross bleeding over from oversight?
So RSA 151, I'm not sure which particular section, is titled deemed licensed. So hospitals, again, are not a really good example, but hospitals are deemed licensed because they are certified by CMS. So I have a CMS team, and then I have a state licensing team, and then there's the external to the state agency, a accrediting agency of the hospital's choice. They are deemed licensed, which means it is expected that they are compliant with everything that's in state law and state rule, but they're overseen by the feds. And it's presumed always that the federal regulations are more stringent than the state regulations. If there's a contradiction there, then our licensing team gets involved or the accrediting agency. We also have a regional office in Boston that works with us on that too. But again, hospitals may not be a really good example because they're different. So, but nursing homes, we would make sure that both our licensing team and our CMS team are making sure that they are compliant with rules and law, federal, state.
This sounds like a horrendous mess.
I don't know what that means.
Well, it means that we have federal requirements and federal regulations and state rules and regulations, and they interact with each other.
So I think it's important to note that the comments that were made prior to my coming up here, there is a discussion about payment mechanisms and an emergency rule. That's separate from licensing. New Hampshire statute requires licensure for facilities that provide certain services. So our bureau oversees that licensing. And to the point that the agencies that were identified on July 1 not being licensed, they are in fact in the process of becoming licensed.
They're in the process of being licensed. You can't list them as licensed entities.
So they're not listed as licensed entities, they're in the process. The activity, whatever system changed, effective July 1, if we were to say as a state, all of these individuals that are receiving services from this handful or less case management agencies that effective 7/1 required a license. Prior to 7/1, they didn't require a license. They require a license. We're actively working with them to get them licensed. If we were to stop their services, then all of those individuals would no longer have services. So we're working in good faith to have that done in 2 weeks or less. And I want to also point out that the Department of Health and Human Services is a very large agency. So to think that licensing is responsible for everything that's happened, I mean, I guess sometimes I get lost in the comment, and I'm sorry, this isn't time for me to, I'll stop. But maybe some of you know where I'm going.
Okay.
We're also
Other questions, comments? Thank you, Peter. Director Morrell?
If any further change were to be made as suggested by Representative Leon, because this is an objection response, the agency would have to request a revised objection. which would end up back before Joe Kerr again.
Does the agency wish to request that? While you're thinking, Representative Corrado?
I'm just wondering whether or not we're just making this too complicated. I don't think that this is as big of a mess as it is, because whenever you bring in intentions and you have two organizations that obviously don't agree, then that's going to create a mess in itself. So I just think we need to look at it as a strictly on a merit basis, if that's helpful.
Okay, well then, does the agency agree to put a revised objection response that would incorporate the clarifications that Representative Leon asked for?
Yes, we agree to that.
Okay, then, yes.
Thank you, Madam Chair. I just want to make sure that with this in process, you'll still be able to get get those people licensed that need to be licensed in order to provide care to this community. Because the process, by the time we're back here and we approve that with that condition, they'll already be in that process of licensing, and it doesn't move faster than that, does it?
Yeah, and to correct, it's not area agencies that are in the process of being licensed because they're exempt. It's those agencies that were part of F that we had initially put in, and the first objection that we're here to discuss today, we removed that. So those are the agencies that we are actively working on becoming licensed.
And
So-
the delay would not interfere with that process?
That's correct.
Okay,
Fantastic.
thank you.
Thank you.
In that case, the agency has requested a revised objection response. Do we need to vote to accept it?
Well, there's another option. You could approve this and then come back through with rulemaking for that one section, and have it fixed that way, if the agency is willing. and then-
Which is the least trouble for everybody involved?
Yeah,
Particularly us.
I would, yeah.
It would be to approve this and start again on regular rulemaking so we can at least get these changes in place.
Okay, is there such a motion?
I'll move to do that, to approve this with the intention of taking into account the measures Representative Leon suggested.
I'll second.
Okay. Representative Leon.
And I do want to clarify that this is a clarification so that there's not misinterpretation, that this rule is already intended to cover anybody licensed under the 151:2B. And the rule change is to make that clear in the future.
Okay.
Thank you.
Is there a second? Oh,
Second.
was seconded already. Yes, thank you, sorry. Any further comments or questions? Okay, the motion is to approve the rule. Those in favor?
Aye.
Opposed?
Aye.
Okay, Senator Lang is opposed.
And
And Senator Ennis. Okay. Okay.
So the next item on the list, the objection response for 2023-89, we have not received that response yet, but they have not met their deadline. Their deadline is until July 31st, so they still have a little more time.
Okay, we will not do anything on that then.
And then
Okay, back to OPLC. Medical imaging.
So with regard to 2023-106, this was a late filed final proposal that did get a waiver for the final proposal deadline. I had 3 comments on it that have already been discussed. The fee issue, the retention policy issue, and then the renewal date issue have all already been addressed. So I had no further comments on this proposal.
In that case, I
Yes.
Move to approve.
Second.
Okay. I have a,
refer to Senator Lang for the motion.
yes, we're in the discussion period, and I have a question. Had some public comment that this board had recently increased its continuing education requirements. And are you familiar with that? And do you know what the statutory authority is?
I believe that it could be referring to respiratory care, not medical imaging. They do have statutory authority over continuing education, or the office does, because it's an advisory board. We did recently have a public meeting on June 8th to discuss this issue. Interestingly, I think stakeholders are mixed about how many hours should be required. But I think the consensus was that the increase in continuing education should not apply to this upcoming renewal cycle. So we do plan to institute rulemaking to address that.
Okay, thank you. I'm sorry, it was the wrong board. Are there any other questions, comments? Okay. The motion is to approve the rule. Those in favor?
Aye.
Opposed? Senator Chandler votes no. Okay. Thank you very much. Okay, we are in other business.
Madam Chair, the next item under other business is Emergency Rule 13679, HEM 504. Staff has looked at this to see whether there does exist a basis for an emergency rule, and it appears, based on the filing from the department, that it meets both the requirements for imminent peril to public health or safety, as well as a potential significant risk of financial impact to the state. But that can certainly be further explained by the agency.
Okay, thank you.
Good morning. For the record, my name is Melissa Nemeth, an attorney with the Bureau of Developmental Services. And HEM 504 is a new rule for provider and provider agency operations. As we have discussed here in the context of some other rules lately, the department has been under a corrective action plan with CMS that we needed to comply with by July 1st that included a few different elements. Some of the key elements were the department needed to ensure that providers of developmental services were able to bill Medicaid directly, because historically there had only been the 10 area agencies had been the only enrolled Medicaid providers, and they had contracted out with service providers. So that was one element that needed to be corrected, as well as ensuring that services to individuals are free from conflict. And so that was, as I said, the department needed to be in compliance with these requirements by July 1st. This has been coming into compliance with the corrective action plan has been multiple years in the making. But we kind of couldn't get to this final stage. We had to first ensure that we stay with the area agencies and what roles we're going to transfer to providers directly. And so that work was still being done up until a few months ago. The contract with area agencies needed to be revised to distinguish their functions. And so that is some of the reason that this was coming as an emergency rule, and there was not time previously to go through the regular rulemaking process. The department sent this out to a draft of this emergency rule out to, it wasn't labeled as an emergency rule. A draft of the rule was sent out to relevant stakeholders at the beginning of May, and gave them a month and asked them to get back to us with any comments. It was made clear to them at the time that due to the timing, it was likely that critical elements might need to be implemented via an emergency rule. The department received a significant amount of feedback, and in fact was able to incorporate a lot of that into the emergency rule that you see before you today. And we are working as we speak on the regular rule to get this, to make sure there are no gaps. To address the points that Attorney Morell had brought up, the imminent peril piece, as I said previously, area agencies contracted with providers. So via that contract, they had what we've referred to as like a screening process or a vetting process for these providers. They oversaw their operations and were able to do the billing. Those are important pieces that needed to be overseen by someone. There could not be a gap in services. So the imminent peril is if there were no mechanism for any oversight or enrollment of these providers, we wouldn't have standardization, and that could put people at risk if there were, no standards for these people to provide the services. As far as the financial concern, if we were not to be in compliance with the corrective action plan by the 1st of July, the state was at significant risk of losing its 50% Medicaid match for these services, which would then mean one of two things. The funds would need to come strictly from general funds that had not been allocated, which could be a significant cost. Or if those funds were not available, it would mean that these folks then would necessarily go without the services. Again, speaking to the imminent peril that this could have put individuals in. So for those reasons, the department felt that it was necessary to go forward with the emergency rule.
Thank you. Senator Lang.
When were you put under a corrective action plan? How long ago was that?
I believe it was in 2017.
So 7 years ago?
I believe that's accurate, yes.
And we have to have an emergency rule for something you knew about 7 years ago?
And we kind of anticipated that question. And as I said, this has been worked on. All of the steps to come into compliance with the corrective action plan have been in process since that time. But this piece about what were the requirements for these providers of services going to be, decoupling that from area agencies, where it had been a part of what they had done and contracted for, we had to first make sure we understood what the functions of the area agency were going to remain before we could determine how they were going to transfer to provider agencies. And that work has the stakeholder work with respect to that has been extremely robust. There are a multitude of subcommittees and advisory councils that had been working on that, and those functions that are going to remain with area agencies, you may or may not have seen, we have filed an initial proposal of HEM 505, so some elements are there, and then the elements that are not yet adopted in the rule were in the contract between the department and area agencies, which was just finalized and approved by governor and council at the end of June. So all of these things were kind of converging on the same time frame.
Follow-up.
So I guess my question is, in here it talks about July 1, which we've already passed. And what does that mean for services that have been provided between July 1 and now that we're out of compliance because we haven't adopted?
This is an emergency rule. It went into effect.
Oh, it's already been in effect since.
Yes, on June 28th, yes.
Been in effect the whole time.
And another complication is that there was the contracts between the area agencies and the provider agencies that were through the end of June to provide those services.
Okay. Anyone else? Representative Leon.
Thank you, Madam Chair. Thank you for getting these rules out. I think that this is a large reason why, as we had the different bills coming through on this, we were really encouraging the department to seek another waiver so that we could go through this rulemaking process in a more measured and noticed way. I just want to say that is why we had encouraged the department to seek another waiver so that we weren't coming in at the last minute. I appreciate the work that you've done, but I'd like to see more forward planning in the future.
Okay, thank you. I do have one comment because I've heard from the case management agencies that they believe they are stakeholders in this process and they were not consulted during this rulemaking. And I wonder if you have any comments on that.
My understanding is that those entities that are providing services, that were providing services to this community and now are part of who would be regulated under here, were included. I do not have the list in front of me specifically, but my understanding is that it went out to a very, very broad stakeholder community. And I don't know specifically which agencies were included.
But it was primarily those who are currently in the business,
Well,
so to speak.
in this rule is for providers, both if they're providing direct service and service coordination. So it went out to providers of both of those types of services. But if an agency was not already providing those services to this community, they may not have been included in that stakeholder outreach because it wasn't known to the department they were the regulated community.
Thank you. Anyone else? Questions, comments? All right, we can't do anything about this, but Director Morrell.
In addition to the Department of Safety under other business, we still have, I believe, 2 final proposals remaining that were taken off consent.
That were taken off consent, yes. Okay. Department of Safety.
Raise your hand in the back.
Okay, so last time the committee had approved the driver's licensing rules and requested that the Department of Safety report back on its internal policy to ensure that forms are not updated outside of the rulemaking process. They had adopted this policy last year and are slowly going through each rule set to look at those forms. But you should have as part of your packages their report out.
Yes, thank you.
Good morning, Steve Lavoie, Assistant Commissioner at the Department of Safety, and with me is John Marasco, the Director of the Division of Motor Vehicles. So the letter that was presented to you was really addressing 3 questions that came up during the adoption of the 1000 rules. The first being how we're addressing the forms issues that we've identified. First and foremost, I want the committee to know, the commissioner and I both want the committee to know that we recognize the importance of having forms go through rulemaking. It's critical. What we're doing at this point is taking an inventory of all of our approved forms and reconciling those against those that are currently in use to identify what those gaps are and what that population is. Once we've identified that population that needs to be adjusted, we'll be determining if there's substantive changes or if there are editorial changes and incorporate those into our current rulemaking schedule as needed based on that risk assessment. So we're working through the process. We do ask for your patience because we have a lot of rule sets to go through, a lot of forms to go through. I don't think every form in the Department of Safety has an issue. We don't know how many, but the ones that are, we will address as quickly as possible. Another question that came up had to do with, actually, I think it was Representative Leon related to suspended driver's licenses and whether those needed to be surrendered to the department. That's a situation where a few years back, the department worked with the legislature to become part of state to state and make some adjustments to statute related to how suspended licenses are handled. We thought collaboratively that we had addressed all the changes that were necessary in statute, but it turns out there were sections that were missed during that process. And that's the situation that we're dealing with here. So we have a group of individuals when their license is suspended that do not need to surrender. However, there is a group that fall under some categories, some exemptions to that, including the administrative license suspensions, the ALS process, that do need to suspend or surrender. Unfortunately, the DMV staff were telling everyone they no longer needed to surrender. That was a missed change in that legislative process. We'll be working internally to determine what needs to be changed through legislative changes, and we're finding a sponsor in the next session to see about whether or not the legislature wants to align both of those processes together. And the key there is the big difference in the driver license is not only a credential that authorizes you the privilege to drive, but also is used as an ID now. And so that's why not surrendering it seems to be something that we would want to consider. And then the third question was Representative Lynn. It was related to a question on non-resident pistol permits. And there was a Supreme Court decision that had indicated that the rules and the forms that we were using were no longer valid. When that decision came forward, we did go through the normal form approval process, adjusted the forms, and those have been in place since that time. But as was pointed out, the rules themselves were not cleaned up to eliminate the language that was no longer necessary. That change has since been filed with the next rule set that was submitted, I want to say maybe a week or so ago. And so those were the three questions that we were reporting back on, and we're happy to take any questions that the committee may have.
Representative Bland.
Thank you, Madam Chair, and thank you for those clarifications. I'd be happy to talk with you about the legislative changes.
Great. Thank you.
Thank you.
Okay.
And I do have that, those pistol rules.
Okay.
We have the initial proposal.
Yes. Representative Lynn.
So, it's, if I understand correctly, from your letter, it sounds like the form was changed back in 2017, but the language in the rule has not actually yet been changed. I mean, it's in the works, but it hasn't actually come to us. Is that correct?
Yes, correct.
That, so that's 7 years since that decision was made. And, I have to say, honestly, that's very concerning. I mean, this is something that sort of concerns a constitutional right, implicates a constitutional right under the Second Amendment. And, the court issues a decision, and 7 years later, the language in the rule that the court has struck down has not yet been changed. That's a concern. That's really a concern that that goes on for so long.
Either that or the department has been ignoring their rule for 7 years.
Well, yeah, understood, and I share that concern, and just to alleviate it, the form is really what's the mechanism to provide these non-resident permits. So the result of the decision has been effectively implemented correctly. The only thing that hasn't been is the cleanup of those rules behind it. So there hasn't been any issue with the implementation of the program after that decision was made. But I agree, those should have been cleaned up sooner.
Follow up.
I mean, I hope that's true, but I guess, the thing that would be of concern to me is if I'm someone in New Jersey, as I use New Jersey because that was where that person came from in the Bach case. But if I'm someone in New Jersey who wants to get a New Hampshire non-resident pistol permit, and if I'm someone that maybe is wants to be a sort of a thorough person, it might be that the first thing I would do is look up the law and the regulations in New Hampshire. And when I read the regulations, I would see that nothing has, that it still contains that language which was unauthorized. So that's, I'm glad things are, we've got the changes in the process. It's unfortunate that it took so long. That's all I'd say. Thanks.
Understood, and that's a fair point.
Director Morrow.
Staff shares Representative Lynn's concern about a time delay between change in a form that substantively affects an existing rule. That would not occur where a form is being incorporated by reference and then the form needed to change because it is being incorporated by reference. Where it would occur is if the form is in addition to the text of the rule, and a change in the form would require a complementary change to the text of the rule. We've discussed that. We're not sure yet how it's best to be, well, it would need to be addressed in legislation, but whether a time period needs to be set for an agency to go ahead and adopt the rule to comport with the form, or what's the best mechanism yet. But it is an issue.
Anyone else? All right. Well, Well, thank you. I wish you luck. You've got a lot of forms that people carry around, and controlling the additions is not a simple task.
Thank you.
Nothing. This was, we already approved the rule. We had a question and they answered it. All right.
So the ones on consent are the last two.
Yes, the last two things off consent.
And the first one is 2023 about ESOL teachers.
Yes. And we had a question that they were going to get back to us on.
Good morning. For the record, Julie Shea, Administrative Rules Coordinator for the Department of Education. I did reach out to the director, and the answer that I was given is that the federal definition and law will always override the state rule. That being said, I don't think a definition within teacher certification would affect any sort of funding for English language learners. Was there something in particular about the definition that was concerning?
Thank you very much. Mike, right now in our statutes on the education funding, it does not define English language learner, which is why my concern was with people looking other places for a definition. The English language learner, as it's intended in the school funding, is for those who need to have that increased level of proficiency in order to bring up their level of competency.
Mhm.
The definition in this rule, which was an addition because the prior rule had
Yes.
no definition.
And I did want to
Yes.
clarify that I did misspeak, and I looked at the older rule and I saw that that particular definition was new, so I apologize for that.
No, thank you. I appreciate this. It's complex. But an English learner could be somebody who is absolutely fluent in English, far better than all their peers, but who also fluently speaks Mandarin at home. And so within that definition, it wouldn't be a need for additional educational funding. It simply reflects, those unique benefits or challenges that a student may have in their needs. I just wanted to make sure that we had on record that this was not in any ways intended to change the education funding formulation, and that it does not sort of dilute those resources.
No, and looking at Title III, where that funding would be, English learner is not defined, and there doesn't seem to be any sort of further clarification or saying that a definition would change the funding for that. I don't know. I'm not an attorney, so I don't know how to speak clearly on that, but
Do I understand you correctly to say that an important element of our educational funding formula is totally undefined?
no, I don't think so.
You just said there's no definition of English language learner.
No, there is in the rule. What I'm saying is that there is no definition of it that I could see. But I was browsing while I was looking. So what I would like to say is that the deadline for this is August 18th. The meeting is August 17th. So if people are not comfortable with the definition in the rule, then I can bring someone back next month.
Senator.
Yeah, so again, I think you're right. I think it's the ELL is defined under Title III.
Yeah.
And that's where the qualifications, and that's where we use as a guideline for our funding formula. And this is relative to teacher certifications. So again, I don't think it's going to cross over in any way, shape, or form as to how it relates to education funding. So I think we'd be okay moving forward with this. With any problem having someone who just went through the education funding formula, the fine-tooth comb, I think we're fine.
Representative Fellows?
Thank you. Since I worked at the Department of Education for 32 years, and I wasn't involved with the English language learners, but I was involved with the adequacy aid. And also I did some, tangential work with different federal funding programs. There's a federal funding program for English language learners. And it's not a lot. Last I knew, it's not a lot of money. It might be a couple $1 million a year. And they define, a couple of years ago, when I was there, they would define English language learners with, I think it was 4 different levels. And one of the levels is that they are proficient now, but they still get some services because they may not, particularly things like the student, high school student who is proficient but still may need some help with technical language, like if they were applying to college, and they get some occasional help with that. So it would be a good question to ask the Department of Education is, when you're funding adequacy aid, what categories of English language learners are you using? I mean, it may be all of them. It may be the first 2 or 3 levels. That would be a good question. I don't think it has any impact on what the licensing.
Okay. Representative Lamb?
Thank you. With all this clarification, I'm very happy to know that we're not throwing a larger net over this. I'm not sure if there's more discussion, but if there isn't, I'd be willing to move that we approve.
Second.
Okay. Any
Thank you.
Okay, we have a motion to approve and a second. Is there any further discussion, comments, questions? Okay, those in favor?
Aye.
Opposed? All right, thank you very much. And the last
All right,
one
the
taken
last
from
one.
consent was
Uh,
HHS evaluation and treatment of income.
Yeah, so it was 2023 100. And I'm not sure what the issue was.
Representative Lamb?
Thank you. On page 8 of the packet, page 3 of the final proposal, there was the note to the agency about those who can prescribe medical services, supplies, or equipment. This is something we dealt with in our committee a lot, about all the different abilities to prescribe. And I think that it might be helpful to amend this language to say medical services, supplies, or equipment that are not covered by Medicaid or which are prescribed by a licensed healthcare practitioner in accordance with state law. Something like that, so that we include APRNs, we include podiatrists, we include everybody who has licensing authority, because we have people who are not included under the definition of physician.
Hi, I'm
What's
this
that?
Nicole Valenzola. I don't even know where you are because I don't have a page 8. I'm sorry.
I think that was fixed in the conditional approval.
It was?
Yeah,
you-
the
it's
conditional
not-
approval's not posted, but I do remember I made that comment, and I thought when I reviewed the conditional approval that it had been rectified.
If we don't have the conditional approval
I'm trying
request,
to
how can
find
we
it.
approve it?
Well, it should be.
Representative Leon, what could you give me like the 0.0 whatever?
Yes, one moment. It
The
is
rule
page
number?
3 of the final proposal. I just know that when we're scanning through, it gets to be a little harder. It is,
654.
Thank you.
Number.
Well, it wouldn't be-
I-4. It's right above the
I-
readopt with amendment.
I-4.
Yes, I-4.
654-0. What? I'm sorry. Senator Lang.
03.
Thank you.
I
03.
4, I sub 4.
I 4. Okay, so again, I'm sorry I didn't introduce myself. Nicole Valenzola, Rules Coordinator, Department of Health and Human Services. Does the version you have, Representative Leon, say medical professional at the end instead of physician?
It does not.
Okay, so
we're
that
not
was
provided with
submitted.
that.
Okay, so that is the
correct.
corrective action.
We do have the conditional approval as part of the packet, and that
Yeah,
was the
it's down
language.
below.
The packet I have does have that.
You just scroll past the final proposal, and there's a conditional approval.
I see that now. I'm sorry. That was really confusing to have the conditional approval in with the final proposal. Maybe it's my newness, but I apologize and retract any concern.
Okay. In that case, do you wish to move to approve?
Yes, so moved.
Second.
Okay, seconded by the committee. Any comments, questions? Okay, seeing none. Those in favor?
Aye.
Opposed? Thank you very much for explaining that, and we'll try and read things more carefully. Is there,
Get rid of things.
yes. Is there any need for the continued meeting?
Not that staff is aware of.
Then let's not have it. Okay. In that case, we are adjourned.